My lord, this to mention for listing, my lord. Tomorrow day after tomorrow.
What matter?
Matter, my lord, pertains to area salary, my lord.
Motion or admission?
Admission, my lord.
Admission after vacation.
It was last issue on 10/11, and
No,
there
no.
2 weeks time was granted on my lord. Now 4 weeks have been elapsed, my lord. They said it is on verge of conclusion, my lord. So, my lord, it is on their stand.
Can it be no last week? Huh? Motion.
Kindly, my lord,
First week of January.
my lord, next week on Tuesday, my lord. Next week, my lord, any date.
Motion to be.
So yesterday one notification has been issued by the registry. Coming week will be only
Day after tomorrow, my lord.
tomorrow, not possible. The first week of January.
Similar fare, my lord.
First week of January.
Lordship, I beg to mention for withdrawal.
When?
Lordship, get alternative remedy regarding a
Okay.
repetition.
Today at 2 p.m.
Item number 45. This will come after this.
Lordship, date may be fixed, Lordship.
45.
Particular date may be fixed, Lordship.
Okay. Mr. Musari, Learned Standing Counsel for the BTC, with consent from the other side, price for listing the matter. After vacation,
On 27.
fair allowed, races shall list the matter. Tar agote paribo. Pabi.
27 January.
First.
First week. 9th January.
Nine, sir. May I please, Lordship, for listing, Lordship, for admission, Lordship, next week, any date, Lordship. Lordship, then Lordship, 5/1, Lordship.
January. Yes, 5/1.
Okay.
5/1 is holiday perhaps.
Maybe Lordship.
Working day or holiday? Pabi.
Walking the lord.
Working. Okay. Yes.
Lordship, I beg to mention for a listing, Lordship. Petition, Lordship, on any date.
Motion or
Admission, Lordship.
admission, January 1st week.
Thank you.
Take a date from him,
The same day, my lord, for admission.
January. January.
Motion item number 1.
May I please, Lordship? Lordship, similar issue, my lord, which has been pending before the division bench, my lord, and
Pending
tomorrow
before?
is the date for hearing, my lord.
Pending before?
Division bench, my lord. The
Okay.
writ
So,
appeal number,
let it be in the January then.
Lord.
Huh?
Prabhu,
After Bihu.
after.
Okay.
A date may be fixed.
Okay. Mr. Ali, Learned Counsel for the petitioner submits that writ appeal number 287 of 2023 is fixed on tomorrow.
Tomorrow, my lord.
Tomorrow for hearing. And as such, he pressed for listing the matter in the third week of January. Fair allowed, races shall list the matter on 21st January.
Obligement.
May it please your lordship. It is directed against an order dated 17/3/25. Relevant page, lordship will get at page 63.
Page 60?
3. Page 63,
Okay.
paragraph 21, your lordship. And 20. In view of discussions and observations made in above, the present.
When this order was passed?
This order was passed on 17/3/2025 at page number 20.
Okay.
Page
Let
number.
notice go at this session.
Lordship, at least, and not your.
Heard Mr. M.S. Laskar, Learned Counsel for the petitioner. This petition under section 12 of the Contempt of Court Act 1971, read with article 215 of the Constitution of India, and Contempt of Court within bracket Guwahati High Court Rules 1977 is preferred by the petitioner for non-compliance of the judgment and order dated 17/3/2025 passed by this court in WPC number 3597 of 2021. And in other connected matters. Peruse the petition and the documents lesson record. Also peruse the order dated 17/3/2025. Let notice be issued to the contemnor returnable contemnors returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. Release the matter after 4 weeks.
অবলাই দর্শক।
2, 3.
May I please your lordship? Lordship, this is a contempt matter of the non-compliance of the order date 19 to 2025. That is page number 15, your lordship. And the operative part is page 16, paragraph 5, where the honorable court directed respondent authorities to dispose of the writ petition by passing a speaking order within a period of 1 month, but nothing has been done, your lordship. till date.
Okay. Third miss.
A. Sharma,
Yes or no, learned counsel for the petition. This petition under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Court Act 1971 and the rules framed thereunder is preferred by the petitioner, namely preferred by 10 petitioners. 10 petitioners for non-compliance of the order dated 19 to 2025 passed in WPC number 3761 of 2023. Where is the petition under the lesson record? And also where is the order dated 19 to 2025? Issue notice to the respondents or contemnors returnable in 4 weeks that be taken by this AD and also by usual process within a week from today. List after 4 weeks.
Item 4.
Please, your lordship. My lord, operative part, my lord, your lordship will please find page 10, my lord.
Okay. Let notice go this is this.
Yes, my lord.
Heard Mr. A. H. M.R. Chaudhary, learned counsel for the petition. This petition under Article 200, under Section 12 of the Contempt of Court Act, read with Article 215 of the Constitution of India is preferred by the petitioner for non-compliance and willful disobedience of the order dated 3/3/2025 passed in WPC number 1138 of 2025. Where is the petition and the documents lesson record, including the order dated 3/3/2025? That notice be issued to the contemnants returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Deputy.
Item 5.
May I please, your lordship?
Your lordship, after a hearing conducted, there's the instruction is not coming, your lordship. So instruction available at this stage.
When
Lordship,
when
it is
the
a
hearing
forward
was
discussion.
conducted. When the hearing was conducted.
Hearing. 19/11/2025.
19/11/2025.
Your lordship, your lordship, instruction, your lordship, affidavit has already, your lordship, sent for vetting. Your Honor, I'm extremely
In
sorry.
which
your lordship.
matter?
This
No,
was-
here direction was to the direction was to Mr. Devry to obtain instruction from the concerned authorities.
Actually, but the department has to take the call.
Your lordship,
Regarding-
access royal, your lordship, we have filed, we will going to file our affidavit as, yeah, affidavit has sent for vetting, your lordship. Because there is some part, your lordship, we cannot,
Otherwise, lordship,
Your
the last,
lordship,
The petitioner has already retired,
Yes, Lordship. In
When?
the year 2018, Lordship.
2018,
28 to 2018, Lordship.
Ah.
7 years ago,
7 years ago.
Lordship.
So already,
On earlier occasion, Lordship.
no,
As earlier dated, many dated, your lordship, that is two consecutively dates, your lordship, 3/9/2025 and 24/11/2025. Time has taken to file affidavit, your lordship. So your lordship, formal notice should go, your lordship. And
no, we are
in the
disposing,
meantime,
sorry. We are disposing of this petition. You deal with the matter in accordance with the office memorandum issued by the government
Yes,
and in the light of the decision of Supreme Court in Rafiq Masi case.
yes, Lordship.
yes, your lordship, but their party is also, your lordship, some
So how can you recover it after 7 years of his retirement?
the amount he has addressed, your lordship, that we have stated in our affidavit, that some part, your lordship, he is liable to return the access trial.
How?
That is.
Under
that
which
is a-
provision of law?
There is an amount that has gone, your lordship.
No.
5 steps.
When the recovery will be made and when it will not be made. That has been clarified in the office memorandum of the government. Do you have that office memorandum with you?
Annex, Lordship. Annex 5, Lordship, page 31.
Instruction received from department, your lordship,
Hmm.
that some director of as per dated, your lordship, later has come from the director of pension Assam, by dated so and so, addressed to treasury officer Khana. As such, that he had already drawn an amount of 1,16,666 and pay only in
No. Are you aware of the office memorandum?
Page 31.
Mr. Pego, your director is authorized to waive up to 2 lakh rupees. Are you sure?
Lordship, subsequent one office notification was issued. Lordship, there is another office Lordship, notification, Lordship. That is 11/11/2021, by which it is extended up to 3 lakhs rupees.
3 lakh rupees
Yes.
by the director of pension.
Yes, Lordship.
Where is that memorandum?
first 5 days.
And above 3 lakh rupees, finance department concurrently declared.
It is below 3 lakhs, Lordship.
Below 3 lakh.
It is below 3 lakhs.
However, amount drawn, amount is 5,09,000, your lordship.
Yeah.
No, Lordship.
Actual amount have to be drawn 5,09,000, your lordship. It is in my instruction, your lordship.
I have annexed the statement, Lordship, Annex 4. The amount is 1,60,066, Lordship, and another amount is 93,260, Lordship. Amounting
So
to
below
to-
3 lakhs.
2,09,902 only,
It's
below 3 lakhs.
calculation part is, your lordship, 6,25,905 minus 5,09,249. That is equals to, your lordship, 1,16,666. So your lordship, only as DCRT. So your lordship, pertaining to that amount, your lordship, he is liable to return the excess drawer to the government exchequer.
So excess drawal is 1,16,666 rupees.
He had already drawn an amount, your lordship, that is rupees 1 lakh, that is admitted fact, your lordship, 1,16,666 only. In excess, your lordship, that is whole amount, your lordship, 6,25,905 minus to 5,09,249, that is equivalent to 1,16,666. that is your lordship as DCRG, and that amount your lordship he is liable to return. So your lordship already affidavit sent for vetting
Your affidavit is not required to dispose of this petition.
as per verification of the documents as he.
As per office memorandum issued by the government. The office memorandum dated 14th of June 2019. And the decision of Supreme Court in Rafiq Masi case. So you have to dispose of his case within a period of 1 month from the date of receipt of certified copy of this order. And in the event of failing to pay the amount within 1 month, the amount will carry 8%, 18% interest. That is the order. Dispose of petition.
Much obliged.
And also keep it in mind that the amount has to be paid by the director, both the director. Interest amount.
They are supposed to place the decision in the appeal filed by the petitioner. That was heard on 19/11/25.
New instruction not received your lordship as the matter is presently under careful examination by the department. Your lordship
Yeah.
sometime will be.
So the last occasion also lordship took time on 24/11. Only decision is to be taken because hearing has already been over. On 19/11.
So next Wednesday, you produce the report.
You.
Heard Mr. M. Khan, learned counsel for the petitioner. Ms. B. Das, learned standing counsel for the respondent in secondary education department. Ms. Das submits that instructions are still awaited and as for listing the matter. In the next week, share a lot, let's list the matter on Wednesday.
Item 7.
Keep you.
17th December.
May it please your lordship. Sure, I have gone through the instruction since the evaluation has been done. But the only thing is that that was not communicated to the petitioner. I have already taken instruction. On the basis of that instruction, your lordship can close the matter.
Close.
Yes.
Okay. Heard Mr. Islam, learned counsel for the petitioner. Mr. K. Gogoi, learned standing counsel for the respondent number 2, 3, and 4. Mr. Tovilda for respondent number 1. One. Yes, yes. Mr. Islam, learned counsel for the petitioner submits that he has obtained instruction from the petitioner pursuant to order dated 1/12/2025, and he submits that in view of the instruction that has been received, that has been placed before this court by learned standing counsel for the respondent number 2, 3, and 4, this writ petition may be closed. Accordingly, taking note of the submission of learned counsel for both the parties, this writ petition stands closed.
But that only one thing, my lord, I am for the legal aid counsel. So that
Okay,
instruction
okay, okay,
details must be
okay.
given, my lord.
Learned legal aid counsel, and in view of the disposal of this petition, rest shall pay the remuneration which the learned legal aid counsel is entitled to as per rules.
I am for number 2 and 3. 4 will not be. 4 will be college.
4 is college. Okay. 2 and 3.
2 and 3.
Okay.
Item 8.
May I please, your lordship? Lordship, the petitioner was working as librarian in the PKB College of Jurhat.
There was a direction to bring on record some
Lordship.
document by filing additional affidavit.
I have filed Lordship.
When?
Lordship, I have filed in 2011, 2025.
But there is no indication in the record to that effect. So, madam, there is office note that no affidavit has been filed.
We have filed,
When?
28/11,
2011. Fine. Night. Okay, in the meantime, we will call for it. We will take it up in the second half. Second half.
May I please your lordship? Matter may be passed on for the time being, lordship.
Notice should go, Lordship. On last occasion, your Lordship directed us to take instruction. But I have seen that the petitioners are from different districts, they were appointed on different days, they regarding their salary. If notice should go, Lordship, we have to take instruction from all the district Lordship. Whether this type of petition can be filed. A petition from Kasar, Dhupuri, Mongoloi, so all are, they have, can you do in a single petition, Lordship. It's a million essay party, if I'm, anyway, Lordship, notice should go.
No, Mr. Sisti, you say, the question is whether they are entitled to or not entitled to.
Yes.
If they are entitled to,
Yes,
then
that-
you ask the respondents to release their amount.
Yes, we have to verify, Lordship, they are from different districts, we have to.
Yes, you have to verify
Yes,
it.
we have to send it to the different inspectors to
Yes.
need their credentials.
Yes.
So for that, we need some time.
No, they are serving now.
Yes, sir, we.
Then
So notice should go, they have come, notice should go, let us have the instruction from the.
no, the object to us on instruction if we can make an attempt to dispose of this petition or not.
No, Lordship, they have not, they have. they have not
You
received
say
from-
they are already government servant. What documents are necessary to verify?
They have not received their salary from January, February 2022,
Mm.
and their report is called in the second of 2025. So
No,
notice-
maybe.
Notice should go, they have also come late, Lordship.
No, they may be late, but on that ground you cannot deny their rightful
No, we
entitlement.
are not denying, Lordship, we are only to notice should go and we have to get the instruction from the district. Because several districts are here, Lordship.
No, that's all right.
Dhubri, Hudai, Dorong, Korimganj, Silchar. Lordship, all of us.
If we issue notice, it will take another 1 or 2 years to dispose of.
No, that's a different thing, Lordship, but
Mm.
process is not good because we have to get the instruction from all the district regarding whether, why they it will not be paid. Every subject matter may be different from in each district, Lordship, so far the petitions are concerned.
Maybe their appointment, date of appointment may be
there.
different.
That is there.
You verify it from the record.
And whether the government and Lordship, they have also their claim is also different, Lordship. Some of them are getting from January, February, some of them from February 23.
So these are very recent years. You can obtain the instruction in respect of the same. So for a small amount, they have to approach this court. They are not claiming anything which they are not entitled to.
No, that is, we are not denying.
Then
Only regarding that, getting the instruction from the different. district.
yeah, so what is the difficulty in obtaining instruction from the concerned inspector of school or the treasury office?
The TAP should complete school, we have to get the instruction. We have to send it, petition goes to all the inspector schools.
Yes,
And for that. whether
you
they-
have already been
whether-
furnished the copy of rate petitions.
They are not-
Yes, Lordship.
You have extra copy?
Lordship.
Furnished to him.
Already
You have already furnished.
Lordship.
How many petitioners are in this petition?
32
Yeah,
32.
From 76.
From which district?
from Kachar,
Hmm.
Sribhumi,
Hmm.
Dhubri,
Hmm.
Yeah, 7 districts.
Sri.
You see, if there is 7 district, he has to obtain instruction in from all those 7 districts. Then you have to furnish 7 copy of this extra copy of this petition to him, so that he can obtain instruction from all those districts.
We furnished 3 copies, Lordship.
How many copies?
3.
3. Then how he can obtain the instruction from other districts, other 4 districts?
Today we will furnish then other 4 copies, Lordship.
So you ought to have prepared the writ petition in district wise.
Lordship.
Okay, let notice go. Heart, Miss
A backup.
Learned Counsel for the petitioner, Mr. Sisti, Learned Standing Counsel for the respondent number. For the respondent name, secondary education or elementary? Secondary education department being respondent number 1429. Miss Borua for respondent number 2. Respondent number 2. Mr. Sisti, Learned Standing Counsel for the respondent number 1429 submits that 3.
3 also.
13429 submits that this petition has been preferred by the petitioners of 7 districts, and he has been furnished copy of the writ petition in respect of only 3 copies of three extra copies of the petition to him, but pursuant to direction issued by this court on 1/12/2025, he has to obtain instruction from 7 districts. And unless the copies of the extra copies of the writ petition are furnished to him, we will not be able to obtain the instruction. And further, he submits that at this recess, notice may be issued to the respondent, so that the necessary instruction can be obtained from all those districts, and he may file his counter affidavit. Accordingly, taking note of the submission of Learned Counsel for both the parties, it is provided that notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. As all the respondents are represented by their engaged counsel, standing counsels. But extra requisite copy of the petition will furnished to them during the course of the day. Release the matter after 4 weeks. In the meantime, the Learned Standing Counsel for the respondent authorities may file their affidavit in opposition.
Much obliged.
Regarding my compression problem, my application is pending also. Also, I direct to consider my application before the DLC also. I have submitted after my father dead also. Thereafter, I have also submitted my reminder application also, which is I have indexed already. My mother pension is still very low also. But it's still there also. So they will take a decision. That's my fair also. Instead of pending also. They will take a decision, DLC will take a decision. Because DLC has lost power.
Pardon? No, where it will go to the district scrutiny committee?
Yes, district level committee. Chairman might have filing.
Yes, madam, where this matter will go? District scrutiny committee or the state committee?
District level committee. I have not passed my DLC.
No, on the other day, Mr. Pegu submits that now the matter will go to the SLC.
DLC complete. Passing DLC matter thereafter.
No, DLC has rejected your pair
No. Still pending, Lordship.
before DLC.
Yes, Lordship. They will take a decision, Lordship. This is my pair, Lordship.
Okay.
Lordship.
Heard Mr. Gogoi, learned counsel for the petition. S.N. Pegu, learned standing counsel for the respondent in elementary education department. Is K. Fukon, learned junior government advocate for the respondent number 9, 4 and 5. Respondent number 4 and 5. Mr. Gogoi, learned counsel for the petitioner submits that the petitioner is agreed for not placing her application for appointment on completion and ground before the district level committee. So those such application was filed on 11/11/2012. Mr. Gogoi, learned counsel for the petitioner submits that the father of the petitioner was serving as assistant teacher and he died in harness on 22nd of October 2012. Thereafter, the petitioner
District level committee.
Thereafter, the petitioner has filed an application on 11/11/2012 for being appointed on completion and law. But the same has not yet been placed before the DLC. And being aggrieved, the petitioner approached this court for issuing direction to the who will place the matter.
Before the DLC. By the DO.
DO.
DO is not a party here.
Director of Elementary Education is a part. And the inspector of school is the part.
He was serving in high school or
LP school.
LP school. LP school, you ought to have added the DO party here.
DO is an executive party.
Lordship, it comes to be my lord, director of elementary.
Better you file an employment application to employ the district elementary education officer. Last line to keep off. And that this petition may be disposed of by directing the district elementary education officer of which district?
Dhemaji district.
Dhemaji to place the case of the petitioner before the DLC. But it appears that the petitioner has not arrived the district elementary education officer Dhemaji who has to place the matter before the DLC. And as such, the petitioner is directed to implement the district elementary education officer as respondent number 6 in this petition. In view of the aforementioned direction, the learned counsel for the petitioner shall file amended constitutional within 1 week from today. Next week.
Item 11.
Was entangled in a criminal case in the year 2020. And as per this honorable court, I was directed to approach the mission director of Samagra Shiksha. Acquittal. Thereafter, I approached the Samagra Shiksha mission director. Then mission director has reinstated me page 59 with a condition that I will not be entitled for the salary during the period of my termination from period 29/1/2021 and 18/3/2024. And during this period, my lord, the similarly situated person salary has been enhanced. But on being reinstated in my service, I have been paid lesser amount of salary. And therefore, I have challenged this on court, the order, page 59. So at least as notice before my.
Notice has not been served.
It is that matter was fixed the previous day. When I approached, my clerk has approached because they are not directly party. This mission coordinator, the main party is Shiksha Kailipara. That has been represented by my friend. Then respondent number 4 and 5, I will start the copy.
Mr. Sarma,
Yes,
your contention is that you have been paid a lesser amount,
yes, madam.
but what are the documents you have placed here?
That's my information. That is my information. Because similarly situated person who were appointed in the year 2012, like me,
No,
Yeah.
you ought to have enclosed
Yes.
the salary certificate of the petitioner.
that is not an expert.
Then
I have simply, my lord, page 59, my term of
Can-
agreement has been renewed.
can this court pass any order without any document? Merely on your submission?
All that areas regarding area salary, my lord. From
Area
the,
salary.
from the date of termination till the date of termination. The date of. Because the trial court has found nothing against me. But I was terminated due to the criminal case, my lord.
Hmm.
And therefore I am claiming for area salary for the.
No, what order was passed by the authority when you have been reinstated in service?
But there is no such order, my lord. Page 59, simply I have been reinstated, but he will not be entitled to any pay back wages of the financial benefit for the period during which he was not in service. But that was, I was compelled not to in service, my lord, not to be in service. Because due to a criminal case, which has been falsely implicated me, and the trial court has found that there is nothing against me. Therefore, the criminal case was ended.
Yes, Mr. Soduri.
One thing I would like to point out, earlier court order was supposed to file an appeal before the SSL. If filed an appeal, there is no order of that on that appeal because lordship looks at page 59. It says the authority of Karbi Anglong Autonomous Council. Lordship, no authority along with the mission director, nothing is mentioned.
Page 54 is my representation, appeal as per honorable court's order.
He has filed an appeal, but whether that appeal has been disposed of or whether any order, nothing has been annexed.
Dispose,
Basis, district mission coordinator has reinstated.
plus
Any insight on?
Yeah, Mr. Sharma, you produce all those documents, including the salary certificate of the petitioner and the similarly situated teachers.
and the outcome of the appeal, my lord.
Yes,
That has
appeal
not
is
been
still
furnished.
pending.
Maybe, my lord, there is no indication.
So you have no instruction on that point. Heard Mr. N. Sharma, learned counsel for the petitioner. Miss learned counsel for the respondent number 4 and 5. Mr. Chaudhary for respondent number 2. Respondent number 2. And any other person? Mr. 64-1. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order bearing memo number SSA/KAAC/TET/RTE/50/2013-14 1200 dated 18/3/2024, which will make it annexure 6. In respect of the last part of the said order, that is within inverted comma, he will not be entitled to any pay, back wages or financial benefit for the period during which he was not in service, issued by the District Mission Coordinator, Samagro Shiksha, Karbi Anglong Autonomous District Council, Depot. And also to direct the respondent authorities, more particularly respondent number 2 and 4, for giving him back wages from the date of his termination till his reinstatement. That is with effect from 29/1/2021 to 18/3/2024 with all consequential benefits in the interest of justice. And also to direct the respondent authorities, more particularly respondent number 2 and 4, for giving monthly salary to the petitioner at par with the other similarly situated persons, like the petitioners, at the rate of rupees 46,000 per month instead of rupees 41,200 per month. Mr. Chaudhary, learned standing counsel for the respondent SSA, has pointed out that the petitioner has preferred one appeal before the mission director and
Page
That is,
54. Page
from
50.
the pleadings also it is here to be disposed of or if.
Page
not
54.
before whom the representation was filed, appeal was filed.
Mission Director,
Mission director SSA.
Sarva Shiksha Abhijan now, Samagra Shiksha.
And the petitioner has not enclosed any document to show that the said authority has disposed of the appeal. And further, it appears that Mr. Sharma has not, no, the petitioner has not enclosed any document to show that he has been paid a sum of rupees 41,200 while similarly situated persons have been paid a sum of rupees 46,000. In that view of the matter, Mr. Sharma, learned counsel for the petitioner, is directed to bring on record the outcome of the appeal filed before the respondent SSA and also the document in respect of the salaries being drawn by him and also being paid to other similarly situated person by way of an additional affidavit before next date. Place the matter after vacation on 21st January.
Mobilized.
Okay. The learned counsel for the respondent number 4 and 5 submits that she has not been furnished with extra copy of the petition. Accordingly, Mr. Sharma is directed to furnish a copy of the extra copy of the petition to Ms. Kempray during the course of the day.
Yes.
Okay. Mr. Chaudhary also pointed out that the name of standing counsel of the SSA has not been reflected in the cause list. Registry shall do the needful in this regard.
Yes.
Your Worship. My lord, here we have challenged the constitution of number 4 Boruazar SMC, LP schools SMC. Not only there was only one meeting, that is on 30/8/2025. On that day,
You are the member of the SMC.
no, I am not the member. 70% of the members' presence is necessary. But on 30/8/2025, my lord, there was lesser number of guardians. So meeting
no,
was deferred.
You tell me, who are you first?
I am father of a student.
Do you have any authority to challenge the
Yes,
constitution of
because my
SMC?
lord, my students' interest is involved there. So 70 number of guardians of the school, wards guardians, they filed an application before the district elementary education officer. 30/8/2025, when the meeting was called, that was an illegal meeting because there was no health worker, there was no pradhan, there was no proper presence of that was deferred meeting. On that meeting was deferred, but secretary the headmaster, by sitting at his house, constituted this committee, and vice president and president from the same family matter. The most important two post president and vice president are the same family, and my lords, four members who have,
No, is there any bar in the act?
because my lord, the headmasters has a semi corruption schemes are there. There are so many allegations. The headmaster secretary made the meeting.
No, you answer my question.
That
Is
the-
there any bar in the act?
But something may not be bar, but it is not fair. It is not fair, my lord. Because from one family, if the main two posts are being captured, then probably they will take the decision according to their wish to excuse money. And that was the allegation against the headmaster who is currently working. He wants that a committee of his choice should be there so that he may get rid of the legal consequences. So our grievances, 70 number of guardians filed an application before the DO that the SMC which has been constituted on 30/8/25 was totally illegal against the provisions of section rule 13 and 14 of the Act. So DO was astonished and he immediately called a report giving 7 days time. They will file a detailed report to the BO. But BO is keeping secret, keeping silence in this matter. BO, headmaster, and the president and vice president, these 4 persons are doing all this. So Lordship may kindly issue notice and let them say that there was 2 meetings. They said that on 16/8 there was 1 meeting which was deferred. Actually on 16 no meeting held.
Okay. Who are appearing for the respondents? Mr. Pegu. You are for respondent number? 1, 4, and 5. 1, 4, and 5. Mr. Soudhury, you are also here? But whether you have any rule here?
No, nowadays, Lordship, the SMC is constituted by the deputy commissioner. He has been given power by the 21 notification, Lordship. The DO only forward the name, and it is the deputy commissioner with the consult approval of the guardian minister. They constitute the SMC of any school.
Okay.
Totally illegal.
There is a notification 2021, Lordship. 27/8, I forgot the date, Lordship. It is question, no?
So it is then totally illegal because it has been approved by DO on the basis of the headmaster's report.
Then the instruction come.
Oh, okay. Oh,
Deputy commissioner is not a party. Because he is the ultimate authority in regarding constitution of any SMC.
yes, Mr. Mahmood.
It
You
is
include
not.
the deputy commissioner as party in?
No,
in
yes,
the-
kindly see is number 3 respondent.
Only additional deputy.
Additional, he is the in charge of education.
That is different for, he is not authorized, he is deputy commissioner. The specific notification is there, Lordship.
I understand that, but even then everything is looked after. If your lordship is on that, then we may add the party. But first, what my learned friend has said, my lord, if that is true, then the entire meeting is void ab initio.
No, that's all right, but you first obtain that notification. Only then your case will be made out.
So আপনার সাথে
Heard Mr. Mahmood, learned counsel for the.
on Friday morning, I will produce that.
We delete the name of SSA because SSA has nothing to do here.
Nothing to do, Lordship. It has nothing to do.
This compulsory education act, earlier it is there, but recently, because this government is changing the notification every day and day. So if it is there, my lord, I will definitely.
It was of 27 October 2021. 2021, this notification is in field.
Then how
It's
the
not-
D-
it's not
How,
being-
how the
Yes,
DO approved this just yesterday?
Okay,
DO is their officer, not our officer.
okay. Mr. SMT 64 respondent number.
One, 4, 5.
1, 4 and 5, Mr. Pegu for?
Pegu na is.
Okay, okay. Mr. Z Pegu for respondent number 3. And Mr. Sodari for respondent number 2. Respondent number 2. And this district elementary education officer, block elementary education officer,
I will represent.
4 and 5 also, 64 and 5. Sure. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the resolution number 1 and 2 of the meeting dated 38/11/2025 and approval of the same
By DO Torok.
dated 16/10/2025 by the
DO Torok.
District Elementary Education Officer Dorong. Mr. Mahmood, learned counsel for the petitioner, submits that the petitioner is one of the guardian of student of number 4, Borwazar ME School. The school management committee of the said school was formed on 30th/8/2025. Thereafter, the secretary cum headmaster of the school has convened a meeting of the SMC, but on that day no resolution was adopted. No resolution was written, and the headmaster, secretary cum headmaster, told the members that the resolution of the meeting will be written in the next meeting. Mr. Mahmood further submits that thereafter the headmaster, who is also a respondent in this petition, with 2 other respondents, have written the resolution secretly, forming the SMC illegally in violation of the rules and also behind the back of the public, and got the same approval from the District Elementary Education Officer. Being aggrieved, the petitioner and others filed complaint, but the same failed to evoke any response from the respondent authorities till date, and being aggrieved, the petitioner approached this court by filing the present petition. Mr. SMT is still learned counsel for the petitioner submits, learned counsel for the respondent number so and so submits that in view of one notification dated
Dated 27/11/2021.
27/11/2021, the school management committee and the power to constitute school management committee is vested with the deputy commissioner,
Commissioner. With
the
the
district
approval of.
commissioner of the school,
Approval
of the
district.
concerned districts,
With the approval of the guardian minister. Lord.
with the approval of the guardian minister. But District Commissioner has not been arraigned as party in this proceeding. And in order to adjudicate the dispute being raised in this petition, implement of the District Commissioner is very much necessary. And accordingly, he submits that the petitioner may be directed to implement the District Commissioner as respondent number 9 in this petition. In view of the submission of learned, now in view of the submission of Mr. SMT Sisse, learned standing counsel for the respondent number so and so. And in view of the notification dated so and so, the learned counsel for the petitioner is directed to implement the District Commissioner Dorong as respondent number 9 in this proceeding. Mr. Sodhuri, learned standing counsel for the SSS, submits that the Mission Director Assam Sarva Shiksha Abhijan Kailipara is arraigned as a respondent number 2, but no relief is being sought for against the respondent number 2, and as such, respondent number 2 is not a necessary party, and he submits that his name may be the name of respondent number 2 may be struck off from the array of this case. There appears to be substance in the submission of Mr. Sodhuri, learned standing counsel for the respondent number 2. Accordingly, the name of respondent number 2 is struck off from the array of this petition. Issue notice to the respondents returnable in 4 weeks. Step upon respondent number 6 and 7 be taken by registered post with ADN also by usual process within a week from today. However, no further notice is required to be issued to the rest of the respondents. They are represented by the standing counsel. But extra requisite copy of the petition will furnish to them during the course of the day. Mr. Mahmood, learned counsel for the petitioner shall file amended cost title within a period of 1 week from today.
My lord, one is small academic point, my lord. The provision of the Assam Right of Children Free and Compulsory Education 2011, my lord. Section 13 and 14. Here says how the SMC would be constituted. Now, my learned friend has said there is a notification of 21. But thing is this, my lord, by notification, the provisions of rules cannot be put away. So the notification itself is illegal. However, I will follow that. What your lordship has asked me, I definitely follow. But here, law is very much clear. Rule is there. According to rule, we must go. But notification is below the law.
No, that's all right. But that notification is not placed on record by you.
No, I admit that.
Even you are not aware of the same.
And it has not been challenged
Because-
by any.
Yeah, that is our question, of course. But actually, by notification, provision of law cannot be taken away.
Okay, you challenge it, you
Yeah.
file amended.
No,
amended
this
petition.
academic talk, just I have told you.
It has not been challenged.
Yes, that is another matter,
Okay.
but cannot be done. Obligement.
May it please your lordship. The petitioner before your lordship is a university established by a state act, my lord. Now, what has happened, my lord, under section 30, subsection 2 of the Assam Private Universities Act, my lord, we are required to frame the first statutes, and the government under subsection 3 of this section, my lord, is required to approve it or suggest modifications within a period of 2 months, my lord. First, we had submitted it on 22/12. That day, the government came back to us with some suggesting certain modifications on 17/4. 2 months, my lord, I'm not on that. Now, we submitted the modified statutes on 15/6/2023, and till date, my lord, there is no response from them, my lord. numerous representations have gone, my lord, they are just sitting over the matter.
When you have filed?
We have submitted on 15/6, my lord, page 43.
15/6/2020.
23. We are in 25, my lord, and they're almost in 2026, my lord.
Page number 40.
Page number 43. I have not
Yes,
annexed.
Mr. Das, what happened?
Take instruction, this may go, otherwise, I have one objection. Society, the petitioners, and as per section 6 of the Institute of Society Act, it's written, every society registered under the act may sue or be sued in the name of the president, chairman, or principal secretary, or trustees as shall be determined by the rules and regulations of the society. And in default of such determination in the name of the person as to be appointed by the governing body of the occasion. Here, my lord, the case has been filed by the register, my lord, in my.
Register of the university, my lord. The society is not before the court, my lord. It is a university. I'm brought into existence by an act, my lord. Turn to page 23.
We have one of the.
The society has formed a university. That's a different matter, my lord. Now the university is an act established by an act of the state legislature, my lord. The university is before this honorable court, my lord, not the society.
Okay, we will see later on, but you obtain instruction why the matter is pending since the year 2023.
And my lord, only observation, my lord, the dependency may not be a bar for them to do it, my lord. Lordship will kindly observe that.
Art, Mr. Deka, learned counsel for the petitioner. Mr. S. Das, learned standing counsel for the.
Respondent number 1.
Okay, respondent number 2, 3, and 4. Then Mr. Pegu for respondent number 1. This petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondents to immediately grant approval to the first statute of the petitioner university, which were sent for approval by letter number GCU/Registrar/2023/334, dated 15/6/2023. As mandated by section 30 of the Assam Private Universities Act 2007. Mr. Deka, learned counsel for the petitioner, submits that the petitioner university was established by an act of the state legislature, namely the Girijananda Chaudhary University Assam Act 2022. Which was notified in the official gazette on 17/10/2022. Thereafter, as mandated by section 30 of the Assam Private Universities Act 2007, the petitioner university has submitted its first statute for approval on 22nd of December 2022. Thereafter, the state respondents have suggested some modification, and thereafter the petitioner university, after modification, has submitted the statute for approval by letter dated 15/6/2023, and till date the same has not yet been approved by the state respondent, and being agreed, the petitioner approached this court by filing the present petition seeking the relief as aforesaid. Mr. Das, learned standing counsel for the respondent number 2, 3, and 4, submits that he may be granted some time to obtain instruction. Pair allowed. So do you issue notice at this stage?
Lordship will issue notice.
Okay. Let notice be issued to the respondents, returnable in 2 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing council, but extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 2 weeks. In the meantime, the respondent authorities shall file their affidavit in opposition. It is being clarified that pendency of this writ petition would not be a bar in approving the statute which was submitted for approval by letter dated 15/6/2023, list after 2 weeks. Is this required?
Not required. Not.
You can take it back.
I'll take it. Now, here, the same university is before your lordship's, my lord. In this case, my lord, we had applied for a course of the law degree, my lord, the 5-year law course, my lord. Inspection was done, it was recommended. The Bar Council also of India also approved, my lord. Now they came up with a letter saying that a press notification has been issued by the Bar Council regarding pending applications. But our application was already approved. Now there has been a subsequent development where the government is writing to the Bar Council, clarify the matter. So in that view of the matter, may I request, at this stage, let notice be issued to the respondents. If your lordship kindly turns to the approval given by the Bar Council of India. I'll first take your lordships to the approval of the government of Assam. My lordship will kindly turn to page 34.
No, Mr. Deka, let the clarification come from the Bar Council.
Lordship may
Because
issue
of-
notice because that development has happened after filing of the writ petition on 3rd of this month. The state has written to the Bar Council to clarify the matter. Notice may go, my lord, in the meantime, because the Bar Council may very well respond. If they say that it is all right, already it is, and then I'll withdraw the writ petition. There will be nothing left because approval has been granted. If your lordship may peruse page 35, my lord.
No, I have seen it.
Bar Council has already approved. Page 35. I think lordship has gone to the 3rd paragraph. After consideration, recognition be granted to and so university under section 7.
So whether by issuing one press release, the Bar Council can deny such permission.
That is another aspect of the matter. My respectful submission is that by the press, I do not come under the press release. Even if your lordship kindly turns to the press release itself, at page 39.
Not be applicable in the case.
It
in
will
the
not be
pending
applicable.
cases.
My petition has already been granted. It is say the Bar Council is saying that because of the drop in the standard of legal education, be considering all the pending applications and no fresh applications will be taken. If your lordship kindly takes up page 39.
Alright.
The second paragraph itself is clear, my lord. Last line of the second paragraph. I'm not troubling your lordship with the entire paragraph.
I have gone through the same.
Yes, pending applications that have not received final approval, as on the commencement date, will not be affected and shall be processed in accordance with law. So there is no bar as such. And my case is already approved.
Heard Mr. N. Deka, learned counsel for the petitioner. And also heard Mr. S. Das, learned standing counsel for the respondent number 3 and 4. Anybody from Bar Council? UFO state. Respondent number 1.
Bar Council notice will have to go. Register, speak both.
The petitioner herein has applied for issuing has challenged the letter dated 4/11/2025 issued by the respondent number 3, which will begin an answer 9. And also to hold that the rule of legal to hold that the press release dated 13/8/2025 And the rule of legal education moratorium. We should make it 3 years moratorium. With respect to Centers of Legal Education 2025 is not applicable to the petitioner university. And also to direct the respondent, state respondent to immediately issue no objection certificate to the petitioner university to commence 5 years integrated law course, which has already been recommended by the respondent number 3 and 4 in the inspection report, and which has also duly been recognized by the respondent number 5. Mr. Dekha Learned Counsel for the petitioner submits that the Bar Council of India, who has inspected your university,
Inspection has been done by the state, my lord.
submits that.
Page 34. Name is shown as standing counsel, bar council. Once some P. Mohanto has received copy, my lord. I have just been informed. Bar Council of India.
Can we take it up after some time? In the meantime, we will try to contact him.
Let me try and connect. If it is Mr. Mohanto,
Yes.
Oh.
Yes,
Just-
I have remembered in one case, Mr. Mohanto entered appearance before,
then I'll just inform him.
after some time.
After some time. Mr. Mohanto, Praveen.
This is regarding my non-payment of leave encashment and gratuity matter.
Not payment of,
Leave encashment matter, leave salary and gratuity. No, inadvertently, my lord, serve copy upon the AG, my lord. I have served to the copy to the council, my lord, it's for AG, my lord. So I pray, my lord, can it be on, my lord, Friday?
this matter, Friday.
Already served the copy to.
Okay. Mr.
Etc.
M. Setia, Learned Counsel for the petitioner, submits that this matter may be listed on Friday so
Friday.
that he may furnish. No, he may serve a copy of the
Yes,
petition.
I have served
notice
already,
to the
AG, council AG.
is it?
12 December.
Matter pertains to completion and appointment lordship. Also already similarly situated matters are pending before your lordship. Challenging and speaking order passed by the Deputy Commissioner of Dhamaji Rajput. Lordship, but petitioner's original application was not considered in that speaking order lordship, as per that speaking order lordship.
It has come to my notice now, my lord. But it was already requested earlier. So once it is requested, my lord, either it is to come for a review or an appeal. Because it has attained its final that resolution. 31422, when it was dismissed for on a round of. It has to be correct.
After dismissal lordship, petitioner has received this speaking order lordship passed by the Deputy Commissioner of Dhamaji lordship. Lordship, new fresh cause of action has arisen lordship. So lordship, after dismissal lordship, he has received this speaking order lordship.
After dismissal.
After dismissal lordship, recently lordship, the authority has furnished the copy to him lordship. He was informed that his case has already been placed before your lordship. And earlier lordship, petitioner's prayer was regarding non-considered lordship. Here lordship, case has been considered lordship by Deputy Commissioner of Dhamaji lordship. But his original application was not considered lordship.
Original application has not been considered.
Not considered lordship. His original application was not considered. But
Mr.
lordship
Paigo,
will find page 20 lordship.
That's 2009.
20.
Otherwise.
Somebody similarly situated matter of pending.
no, on the other day, in respect of another,
That's why I'm not today, this come today.
Other day, I was directed to obtain instruction. There is fixed on probably some 16 or something.
7th of January, Lord.
No, 7th.
7th of January. Challenging the same speaking order, Lord.
Please come later.
17 January. Okay.
7 January. Case number 3.
Mr. D. Bhuya, learned counsel for the petitioner submits that
25.
similar subject matter. Now, in connection with the same subject matter, some other writ petitions are also pending before this court, being WPC number
6839, Lord.
6839 of 2025.
2025.
And the same has been listed on 17th of January.
Yes, Lord. 7th of January, Lord.
7th of January.
7th of January, Lord.
And
7th.
he pressed for listing the matter along with those writ petition. Along with that writ petition on 7th of January, pair allowed, recess and list the matter on 7th of January.
Lord, item number 25, Lord. Same
Same.
issue, Lord.
25 same. 3, 4 and 5.
Item number 25, Lord. Same issue, Lord. Same speaking order. Oblige, Lord. Yeah.
I actually, small mistake that I have done regarding that, item number. Item 12. That notification is, I have entered that notification regarding the only secondary department. So it was directly written there, it is not for immediate. That notification is only for the secondary department. So here, they did not implement, not. regarding-
Applicable in
not
case of
applicable.
petitioner. Okay, we'll omit that.
And I will get an instruction from the district regarding it. Then we can be corrected. So he no need to include applicant as a party.
Yes,
That implement not,
not required.
not,
Okay,
applicant is not.
Then
you are not required.
post title need not be corrected.
No, the SSA has been
FSA
Strike
only,
off.
that is not required. And I have
Okay,
get an instruction
okay.
from the district.
So that post title may not be corrected now.
No, has to be. SSA, name of SSA has been struck off.
Okay.
May I please, Lordship. My lord, here. Yes, second 17. My lord, we have challenged the impugned order, that is page 49, operative portion page 52, my lord. Here, this is the impugned order we have challenged, and the main ground is page 52. Kindly see the middle portion. Accordingly, matter is placed before SLSC, that is so and so, and it was found that the name of petitioner was recommended by DSC Dhubri for provincialization of services as per Act of 2017. The proposal was placed before the SLSC as well as joint committee constituted by government, forwarded to the SSA after for verification of the petitioner's name in the dice. The petitioner Anjora Khatun does not fulfill the criteria as laid down in the minutes of the joint meeting, since the name of petitioner does not appear in the dice code data of 2011-12. Accordingly, SLSC decided and authorized D Assam to reject the claim of the petitioner for provincialization of services as per Act of 2017 by issuing a speaking order. Lastly, my lord, it is says second para, but the petitioner name appears in dice code 2011-12 here. Hence, SLSC as well as the joint committee could not recommend the name of the petitioner Anjora Khatun for provincialization of services as per Act 2017 against Uttar Ghunimari LP School. And according claim of the petitioner is hereby rejected. Now, my lord, my submission is this: I am in that school, that Ghunimari LP school, since the year 2004, my lord. And my lord, as per section 4 of the 2011 Act, it is deemed to be provincialized. And my name should have been forwarded along with the other names of the school for the purpose of provincialization. That was mistake committed by a DSC. Then, my lord, the DO wrote a letter. My lord may kindly see, First, kindly see the provincial election order, page 33, my lord. Here, operative portion, page 34, my lord. Uttar Ghunimari Village LP School, only one teacher, Abdul Rashid. Second, Rashid has seen, page 34 bottom, serial number 350. Here only Abdul Rashid headmaster's name is there, and second post kept vacant. But second post should have been filled up by me. That was the mistake committed by the DO, and that DO. That is why when I brought this matter to the notice of the DO, he wrote a letter. Kindly see now page 38, my lord. Sorry, 37, my lord. 37, Annexure 10. With reference to the subject cited above, I have the honor to inform you that the District Scrutiny Committee observed that earlier the name of Mughal Hussain, assistant teacher, was recommended by the District Scrutiny Committee through oversight. The actual name should be Anjuara Khatun, assistant teacher, instead of Mughal Hussain, assistant teacher, in Uttar Ghunimari Village LP School, under Bilashipura Education Block. Hence, the District Scrutiny Committee resolved to request the DE Assam for cancellation the recommendation of Mughal Hussain, assistant teacher, and requested to issue service suspension order against Anjuara Khatun, assistant teacher, in place of Mughal Hussain. Now, this Mughal Hussain, he is an imaginary person. Actually, there is no person by the name Mughal Hussain. So he is not before anyone. He is an imaginary person. I don't know how it was made. That's why the DO said that that was a mistake. It should have been filled up by Anjuara Khatun. So thereafter, my lord, several communications have been made. That is page 38 now, lordship, kindly see. Here, the DO again has written a letter to the director with reference to the subject cited indicated above. I have the honor to inform you that Srimati Anjuara Khatun name was posted as assistant teacher of Uttar Ghunimari LP School, having dice code number so-and-so for the provincial election of service, who has been working in the school since 15/7/2004. So, my lord, what is said that I have no dice code, that is not there. At present, my lord, dice code is along with the name of the teachers. But earlier it was not there. Earlier the dice code was in the name of the school. And in that school I was working at that relevant point of time. So the DO says that she is also having the dice code. Now, in similar situation, my lord, some persons' names were dropped. And they approached the Honorable High Court, and the Honorable High Court gave them complete relief. And it was, Lordship may kindly say, page 64. My lord. Yes, 64. Here, my lord, various sections of the Act of 2011 has been discussed. Now, operative portion may kindly see page 67 onward. That's 67, para 5, lordship. The provision of section 4 of the Act of 2011 and the relevant portions of the judgment cited by the Learned Council are reproduced herein below. Section 4(1) of the Act of 2011 provides as under: the services of the employees of all the eligible Fencer education institutions under Section 3 shall be deemed to have been provincialized on the date of coming into force of this Act, and they shall become employees of the state government with effect from the date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on date of coming into force of the Act. So, all these qualifications I do have. Now, at last, while discussing all these things, the Honorable Court said this, now that may kindly be seen page 69, madam. Page 69, para 9, madam. I have gone through the contents of section 3 and 4 of the Act of 2011 and also gone through the contents of section 24 of the Act of 2011. I have also gone through the judgment passed in review petition number so-and-so and the judgment dated so-and-so of this court passed in WC so-and-so. Considering the facts and circumstances of the case of the petitioner in WBC number so-and-so and the case of petitioner in this case, I find that facts, the circumstances of the two cases are quite similar. Considering the provisions of section 4 of the Act of 2011 and the judgment passed in review petition number so-and-so, I am in total agreement with the judgment passed by the coordinate bench, that is so-and-so, in WBC number so-and-so. Therefore, I am of the considered view that the petitioner should be deemed to have been provincialized on the day the other employees were provincialized. Hence, the writ petition is allowed and the respondents are directed to issue necessary orders within a period of 2 months from the date of receipt of the copy of this order. So, this is one judgment, my lord.
Mr. Mahmood, this coordinate bench of this court has relied upon another decision of a coordinate bench.
Yes.
Where is that decision?
Next.
That's yes. 70. That's 70, Lordship.
70.
Yes.
Yes, Pegu, you were appearing for the respondent?
Mm. 2004. 17 Act would not apply in my case because I am of 2004 and my contemporary has been forwarded under the Act of 2011 when it was not struck down. So that 17 would come if I am the appointee after 11 or after the struck down. But here,
No, Mr. Mahmood, now you tell me under which provision they will appoint you.
3 and 4. 3 and 4 because
3
on
and
that
4.
day I was there and my dice code is there, my lord.
3 and 4.
3 and 4 of 2011 Act.
That has been struck down.
No, it struck down in 2016.
Maybe.
In 2016, and the this headmaster who has been in it has been provincialized as per the Act of 2011. I am with him. My post was due to bona fide mistake, my lord. Mughal Hussain name was forwarded. The authority found that Mughal Hussain his existence is not there, so it was kept vacant. When I brought the matter to the notice of the DO wrote a letter to the director that kindly get the wrong corrected, and it is not corrected till that. Now they are saying this and that. Now since 2004,
Her name was not forwarded. It was not challenged.
subsequently forwarded. Why I will challenge? Because they realized their own mistake and they recommended that my name should be there. So unnecessarily I will go litigation. So a very simple case, my case should be considered along with the headmaster's post.
Mr. Mahmood, your case is not so simple as submitted by you. Have you seen the repeal provision of the Act 24, Section 24? Section 24
Section 24
of the Act of 2017.
No, that is there, my lord. But that is, my lord, actually,
How
I
to
understand that.
overcome that?
I may also go through the provision of 2017. But that is a long process. It will issue summons to other persons, different stakeholders. They will come submit WS, then issue would be framed. Then
No. Section 24 of the
17.
Act of 2017.
The protected who have been provincialized prior to 23/9.
Yes, that section also what I have said is here. However, all the teachers whose services were provincialized prior to 23/9/16 shall continue and their cases shall be reviewed as per the eligibility norms set for provincialization under this Act. So, my lord, 23/9/2016 is the
So
cutoff date.
now your case has to be considered under the Act of 2017.
They say this, but we
No,
say,
the Act says. Section says.
kindly say, provincialization order or provincialization order, Lordship. I'm again drawing your Lordship kind attention.
No, that provincial, by that provincialization order, your service has not been provincialized.
My lord, that is true. That not provincialized, that is why they committed the mistake. That was not my mistake.
Hmm.
So, my lord.
No,
this
now
is-
under the said act, can the state respondent can consider your case?
My lord, it is the settled position of law. State cannot take the benefit of their own mistake.
Hmm.
State has committed mistake. Instead of sending my name, they send an imaginary name, Mughal Hussain. Mughal Hussain is
No.
no here.
That is all right. He has also not been disputing it. But the question is under which provision your case has to be considered? Under the Act of 2017?
My lord, I said section 3 and 4. It is deemed to be provincialized if I am on
No,
that day.
that act is not there now. That has been struck
No,
down.
no, at the relevant point of time, it was there.
Maybe, but nowadays it is not there.
Yes, nowadays it is not there.
Hmm.
And I am for not nowadays. I am when it was 2011 Act. my lord.
No, now you are nowhere.
No, actually, my lord, may kindly say the judgment, it is dated 3/10/2018.
Hmm.
3/10/2018, this judgment provided relief to the petitioner.
Hmm.
And the act was struck down in 2016.
Hmm.
Kindly consider this aspect, kindly appreciate
No,
this.
now first you obtain instruction as to whether this petitioner was appointed by the government or not.
No, at that time it was Venture School.
No, the petitioner of these two writ petitions, which you have referred to
Yes,
today,
yes.
whether the government has appointed them or not.
Their latest version, that I don't know. This order I have, but whether they have actually.
No, the question is similar order this court can also pass, but the problem is that they will not be able to implement it.
No, my lord, your
In
lordship's
view
order
of
definitely. will be
section
followed.
24.
My lord, let me clarify your lordship in a better manner. The Act of 2011 was abolished in the year 2016. And these orders have been passed in 2018. So after strike down, because at that time when it was struck down, before that I became entitled to get provincialization. So similar is my case, madam. So I will cover by that. Lordship may kindly pass the similar order. I hope that I would get the benefit. I am a lady, my lord. Since 2004, I am giving honorary service. And for no fault of me, kindly consider this judgment. Let them consider my case in terms of these two judgments. And if the.
No, but yes, Mr. Siste, whether these petitioners were appointed by the government or not.
Anyway, whatever there is a Supreme Court case on that when the act is struck down, under that act, no benefit can be given. The full bench decision law. So when the decision is there, whether under the struck down act, something now we can. That cannot be done.
No, first they would tell me, you obtain instruction
Yes.
whether these petitioners were appointed or not. These two petitioners.
Yes.
Okay, we'll listen the next week.
Yes.
Heard
Well,
Mr. Mahmood?
kindly parted, keep it parted, kindly. So no, but we have, lordship has heard it at length.
Okay.
No, let them bring instruction.
Okay.
Because lordship has
Mr.
already.
Mahmood, learned counsel for the petitioner. Mr. SMT System for the respondents in Elementary Education Department. Elementary Education Department. The petitioner herein is agreed for non-provincialization of her service as assistant teacher of Uttar Ghunimari LP School, although she has been rendering her service since 18/7/2004. Mr. Mahmood, learned counsel for the petitioner submits that the said school was provincialized provincialized with effect from 1/1/2013
9/12/13.
by order dated 9/12/2013 with two posts, one assistant teacher and one head teacher and one assistant teacher, by showing one post vacant. And in the said vacant post, the DLC has recommended the name of one Mohammed
Mughal Hussain.
Mughal Hussain. But said Mughal Hussain has no
Existence.
no existence. And thereafter, the petitioner approached the district elementary education officer. And then realizing the mistake, the district elementary education officer of which district?
Dhuri.
Dhubri has written a letter to the director of elementary education Assam, but the same failed to evoke. What is the impugn order? Page number?
Impugn order, my lord, page 45. Sorry, page 49. Operative portion, page 53. Second,
Failed to evoke any response. Thereafter, the petitioner has preferred one writ petition before this court. And before this court, being WPC number 5945 of 2011, wherein this court was placed to direct the respondent authorities to consider the case of the petitioner by the state level committee for provincialization of her service in terms of recommendation made by the district committee. As indicated in the communication dated 7/5/2015 and 17/11/2018. Thereafter, the director elementary education has passed the impugn order dated 1st of October 2024, by which the claim of the petitioner has been rejected, and being agreed, the petitioner approached this court by filing the present petition. Referring to two decisions passed by two coordinate bench of this court in WPC number 3499 of 2014, dated 22nd of January 2019, and also the decision dated 3/10/2018 in WPC number 6804 of 2017, Mr. Mahmood submits that the present petitioner is similarly situated with the petitioners of those two writ petitions, and as such, similar relief may be granted to the present petitioner also. Having heard the submission of learned counsel for the petitioner, Mr. S.M.T. Siste, learned standing counsel for the respondent in elementary education department, is directed to obtain instruction as to whether the petitioner in WPC number 3499 of 2014, namely Soilendra Nath Sharma, and the petitioner of WPC number 6804 of 2017, namely Shri Dilip Das. Dilip Das was appointed by the respondent or not in compliance with the direction issued in those writ petitions. And if they have been appointed by the respondent authorities, the appointment letter shall be produced before this court on next set. List the matter on 19th. A copy of this order be furnished to Mr. Sisti during the course of the.
I'll keep it parted, my lord.
Okay, SSL list the matter as parted.
Highly attached.
Petitioner is headmaster of Pangmol High School, my lord, rendering service since 98, my lord. Page 22, my lord. Page 22, my lord. CM brought on allegations regarding that, my lord, page 22, last persons, number 7, Pangmol High School. It is reported by so and so.
No, Mr. Islam,
My lord,
this school is provincialized school?
provincial,
Okay.
provincial.
You are the regular headmaster.
Regular headmaster, appointed by the inspector of school, Dima Hassan, my lord.
You have been receiving regular salaries,
My lord.
At the ad hoc basis.
Ad hoc basis, that is.
ad hoc basis.
Very good. My lord, there is no allegation, but only allegation brought against me that instead of staying
So
at
what,
quarter, my lord, I am staying nearby the village. That is why quality
You have
education
been
was
placed under suspension on who is that?
on, my lord, 27/6/2025, my lord.
27/6/2025. Thereafter, it has not been reviewed.
Not reviewed, but annexure 4, page 19, my lord. Annexure 4, page 19, my lord. Once appointed, my lord, without departmental procedure, my lord, due procedure of law, petitioner may not be terminated from his service. But instead of suspension, my lord, the petitioner was terminated from his service. Only allegation, my lord, page 22, last paragraph. May I read, my lord?
Where is the termination order?
Annexure 7, page 24, my lord.
24. So you have not been issued any show cause notice?
There is no any departmental procedure. Directly, I am terminated.
No, whether any show cause notice was issued to you?
No, my lord.
Heard Mr. B. Islam, learned counsel for the petitioner. And he does for the respondent number
1, 2, and 4.
1, 2, and 3. And you? Respondent number 5. Respondent number 5. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 27/6/2025 by which the service of the petitioner has been terminated. But Mr. Islam, going by this order, it cannot be said that your service has been provincialized.
My lord, annexure 3, page 18, my lord. Provisionally approved on, my lord, 18 to 2000, my lord.
That is only approval for appointment as headmaster, but when the school was provincialized, you come to the last line of Annexure 7. Here it is stated that he will not claim for the post if his name is dropped whenever the school is provincialized.
My lord,
It means that your school has not been
not been
provincialized.
provincial. Okay. Very much.
If the school is not yet provincialized, can you maintain this writ petition?
In case of my lord, annexure 4, page 19, my lord.
But
What?
the impugn order is passed by the state respondent, inspector of school.
Annexure 9, which he has, your lordship, that is.
Annexure 7.
Annexure 7.
19, your lordship. That was on long back down, your lordship, which can be 2009, and this was this fresh, your lordship, 27/6/2025. And here it was clearly mentioned that the appointment made by the school SMC of Pangmore High School under resolution. Resolution has already been taken on 23/6/2025. That the senior, Sri Gopal Gindra, it is the senior most of Pangmore High School, has been upgraded, your lordship, upgraded as headmaster. Vice Sri Abu Bakr Siddiqui, which is the present petitioner, has been terminated here provisionally approved. And that earlier order was provisionally approved. It was clearly mentioned in the state order, your lordship, which he has denoted.
Last line.
It was provisionally appointed, not
Okay,
permanent.
okay.
And moreover, your lordship, it was clearly mentioned, he will not stay for the post.
Okay, all right. Terminated. Though Mr. Islam has made a contention that the service of the petitioner has been provincialized and he has been receiving regular salaries, yet going by the Annexure 7, the termination order, it cannot be said that the school has been provincialized. School has been provincialized. But it appears that the said order of termination was passed by the inspector of school Dima Asau Haplong on 27/6/2025. And let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, and 4, and 5. 4 and 5, since they are represented by their English council, by their respective standing councils, but extra requisite copy of the petition may furnish to them during the course of the day. Step upon respondent number 6 and 7 be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. In the meantime, the learned standing council for the state respondents shall file their affidavit in opposition. List the matter after 4 weeks.
Copy the debugger.
Similar order, which is page 92 for grant of area salary. Your lordship had already passed an order on 8/9/2025. Where page 92, 87 also there is an order, but 92 is identical, lordship. Oh, lordship is allowed to dispose of the presentation. Absolutely identical, Lordship. Only
No, Bora, you go through this order and the pair made by the petitioner. If the petitioner is similarly situated with the petitioner of that writ petition, we'll pass similar order.
That has to be verified by the department.
Department will definitely verify. First you go through the order and the pair of the petitioner, present petitioner, whether they're similarly situated or
but
not.
after some time it can
After
be
some
taken.
time, yes.
No, absolutely similar, Lordship.
After some time, in the second half, you inform this court whether similarly situated or not.
I've informed Mr. Mohanto, he told me that he's willing to. It is reflect, SC Bar Council. It is reflect, SC Bar Council. Name is not prepared.
No,
SC Bar.
Mr. Mohanto is available in the court. He left.
She can receive copies, my lord. I have talked to Mr. Mohanto, my lord. I have had a telephonic conversation with Mr. Mohanto.
Okay.
You can accept the notice on behalf of respondent number 4.
কবে ডিক্টেশনটো কোনে লৈছিল ৰাজীৱে লৈছিলে ন ডিক্টেশন দিয়া হৈছে Okay, we will pass the order.
Only issuance of notice. And Lordship may observe that pendency will not be a bar for them to concern. Only that.
So part of the order has already
Been dictated.
We will continue.
I am obliged.
May it please, Lordship. Lordship, matter pertains, my lord. Lordship, matter pertains to prolonged unauthorized suspension, my lord. If your Lordship takes down to page 20, your Lordship, there is the impending order, your Lordship.
Page number
20, your Lordship, Annexure 3.
But you are serving in police department.
Lordship, I am as head chairman.
Okay, sorry.
Lordship. I was a teacher, my lord. I was arrested in an SCB case, my lord, subsequently released.
Okay. No, another matter is listed today,
Lordship.
who is of the police department. Perhaps it is bench 3 matter. One matter is there. Police. Police or against the private case. It was bench 3 matter now. 3.
I am suspended by Director Elementary Education, my lord.
Where is the suspension order?
Page 20, your Lordship.
Page 20.
Page 20.
4/1/2025. You have been arrested?
I am arrested on 11/12/2024, and my suspension is with effect from 11/12/24, my lord. If a Lordship takes down.
Whether review was done by the.
Nothing has been done till date, my lord. It's my humble prayer, my lord. No review, no charge sheet, no extension has been filed.
No such suit.
Nothing. Till date, my lord. And my date of suspension is with effect from 11/12/24, my lord. Today is almost 1 year, my lord.
Mr. Katonier, the office memorandum issued by the Chief Secretary. If a search sheet is not filed within the period of 3 months from the date of his arrest, so this suspension order has to go.
That instruction today, obviously, I don't have policy. Well, may issue some notice so that I can obtain the instruction. If there is a review order or there may be some so-called notice. After vacation.
No, before vacation, the only information is whether it is reviewed or not. And whether search sheet is filed or not within 90 days. In view of the.
Short notice. immediately after the opening. So that I can obtain instruction, that's file affidavit also required.
My lord, it's a
No,
covered
no,
case, my
before
lord.
vacation, you obtain instruction. Because the, the person is under suspension. Heard, Mr.
RHOD, your lordship.
Learned counsel for the petitioner, Mr. Khatoni, learned standing counsel for the respondent in secondary elementary education department. The grievance being sought to be addressed in this petition is that the petitioner, while he was serving as head teacher of 1148 number Azad LP School under Block Elementary Education Officer South Sribhumi of Sribhumi district, was placed under suspension with effect from the date of his arrest, that is 11/12/2024. 2024. Void impugn order dated 4/11/2025.
4124.
4/1/25.
25, your lordship.
25. And since then, the suspension order has not been reviewed by the respondent authority and no so cause notice has been served upon him. So cause notice stroke search sheet has been served upon him. And being aggrieved, the petitioner approached this court by filing the present petition. Whether you have filed any representation?
Lordship, I filed representation, my lord, page 21, your lordship.
Okay.
NHF court. That is on 8/5/2024.
The learned counsel for the petitioner submits that the petitioner has filed one representation on 8/5/2025 to the Director Elementary Education, but the same failed to evoke any response till date. Para. In view of the submission of learned counsel for the petitioner, and also in view of the grievance being sought to be addressed in this petition, this court is inclined to issue notice to the respondent returnable on 19. However, no formal notice is required to be issued since Mr. Khatoniar entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Place the matter on 19th. In the meantime, Mr. Khatoniar shall obtain instruction as to whether the suspension order dated 4/1/2025 is reviewed within the period of 90 days, and whether search sheet has been submitted to the petitioner or not, and as to what is the status of the letter dated representation dated 8/5/2025 filed by the petitioner to the Director Elementary Education Assam, list on 19.
Highly approved.
May it please the Lord. Lord, the petitioner, my lord, was appointed as an assistant teacher in the year 2010, my lord, in 1122 number Borpeta Nursery Cum Primary School. In the year 2017 and 2019, for two major accidents, my lord, because of which, my lord, he became 50% disabled, my lord. Now, my lord, will kindly come to page number 39. One order dated 21/2024 was passed, wherein, my lord, a list of excess teachers was prepared, my lord, and they were transferred to single teacher schools. And the name of the petitioner, my lord, is in serial number 48 at page 41, serial number 48. After, my lord, he submitted representation that since he is a person who is aged around 55 years and he is suffering from disability, so his transfer may be stayed. Then, my lord, will kindly see page number 48. He was asked to join immediately in the said school. And accordingly, my lord, at page number 49, that is 19 to 2024, he joined in the said school. That is Saput Pothar Sor LP School. Thereafter, my lord, lordship will kindly come to page number 51. Subsequently, one order on 12/3/2024 was passed, wherein the post was also transferred. Person along with the post was also transferred. Subsequent to that, he submitted several representations, my lord. You will kindly see page number 84. 84. This letter, my lord, was sent by the District Elementary Education Officer to the Director of Elementary Education, wherein they admitted that at the time when this excess teachers list was prepared, they had no knowledge that the petitioner was suffering from disability. Lordship may kindly see, if I may read, my lord. I have the honor to forward herewith the application received from Dewan Abdul Kaim, 80, who has prayed for cancellation of his rationalization order due to his physical disability. In this regard, I would like to inform that DIS Borpeta had submitted a list of excess teachers during the rationalization process in which the name of Dewan Abdul Kaim was also included. That, madam, the excess teachers were allowed to render their services in various single teacher schools as per approval of DLC headed by ADC. Accordingly, Dewan Abdul Kaim was also allowed to render his service in Sapori Pothar LPS under BEEO Mondia. And subsequently, the proposal was sent to your good office for approval, and the approval was received from your good office by order dated so and so. Now, my lord will kindly see that Madam DIS Borpeta has informed that they were not aware about the physical disability condition of the said teacher during the rationalization process, and therefore the teacher was listed in the excess teachers list, and consequently he was rationalized. That, madam, after the rationalization, the concerned teacher has submitted the physical disability certificate along with an application which was brought to the notice of the ADC chairman for rationalization of teacher Borpeta. Now, lordship will kindly see page number 92. After that, the Director of Elementary Education, madam, issued this letter to the District Elementary Education Officer at page number 92, madam. I would like to state that the information regarding rationalization of Dewan Abdul Kaim of so-and-so school submitted by you wide letter under reference is received by this directorate, and the same has been verified at this end. In this connection, you are requested to take appropriate steps for readjustment, rationalization of Muhammad Dewan Abdul Kaim in a convenient school considering his physical disability and PTR of the school. So they instructed that you kindly readjust him in a convenient school. But even after that, my lord, the district authority has not been doing anything, my lord. That is our grievance, my lord.
Yes, who is appearing for the respondents? So where is your disability certificate?
Disability certificate, my lord, is '57. '57 and '58. Issued by the Joint Director of Health Services, Borpeta.
Yeah.
And the director has also verified this, my lord, Director of Elementary Education, my lord. Thereafter, the district authority was requested that you kindly readjust him to a convenient school.
So your case is covered by which clause of the OM dated 2nd of February 2024?
Okay.
Clause H, page number 112. H. H. Oh, where is the letter of the director?
Director's letter, my lord, is at page number 92. Second paragraph.
So, Madam, you obtain instruction from the district elementary education officer. Or Mr. S. Das, learned counsel for the petitioner. And Ms. N. Pukon, learned standing counsel for the respondent in elementary education department. And Ms. K. Pukon for respondent number 3. The petitioner herein has challenged the transfer order dated 28/1/2024 by memo number BEE stroke rationalization stroke M stroke 2022-23 stroke 7688-7694 issued by the member secretary of district level committee cum district elementary education officer Barpeta, whereby the petitioner has been transferred from 1122 number Barpeta, Barpeta nursery cum primary school under Barpeta block to Sapor Pothar Sor LP school under Mondia block Barpeta. Mr. Das, learned counsel for the petitioner submits that after the rationalization order dated 28/1/2024 being passed, the petitioner who was serving as assistant teacher under the elementary education department has been transferred from 1122 number Barpeta Nursery cum Primary School under Barpeta block to Sapor Pothar Sor LP School under Mondia block. And the petitioner is aged about 56 years and he is suffering from 50% locomotor disability. And the above rationalization cum transfer order has been passed in contravention to the provision of the Right of Person with Disabilities Act 2016 and the rules framed thereunder. And other applicable departmental orders and notification. Mr. Das further submits that after realizing the mistake committed by the authorities in transferring the petitioner, the district elementary education officer has written a letter. Barpeta has written a letter to the director of Elementary Education Assam on 28/3/2025 and the no. When this letter was written by the District Elementary Education Officer to the director,
Page number 84.
80?
84.
84. The District Elementary Education Officer has written a letter on 12/9/2024 to the Director Elementary Education, Assam Kailipara. Informing the physical condition of the petitioner. And thereafter, by letter dated 28/3/2025, the Director Elementary Education Assam has directed the District Elementary Education Officer Barpeta to take appropriate step for readjustment stroke rationalization of Mohammad Diwan Abdul Qaim, assistant teacher in a convenient school considering his physical disability and parent teacher ratio. PTR, what is meant by PTR?
Parent teacher ratio. People's teacher ratio.
People's teacher ratio of the school. But nothing has been done by the District Elementary Education Officer Barpeta till today. And being aggrieved, the petitioner approached this court. The submission of Mr. Das, Learned Counsel for the petitioner, needs further consideration at this stage. Ms. Okon, Learned Standing Counsel for the respondent number so and so, is directed to obtain instruction about the status of the letter dated 28/3/2025 written by the director to the District Elementary Education Officer Barpeta. List the matter on Wednesday, next Wednesday.
Highly obliged.
Yes, more. Bara, you have gone through it? Yes. What is your submission? Similar order. Okay,
Page 92 ordered.
92.
Only the date of representation would be changed, nothing else. Yes. Para 9.
Okay. Taken.
Where is that? Let them file separate representation. They file in common representation.
Okay, separate.
Yes,
Individual representation.
deeply obliged. Deeply.
May I please, Your Lordship? My lord, this matter relating to compassionate appointment. My lord, with the intervention of this honorable court lordship, the district level scrutiny committee has recommended the name of the petitioner. Thereafter, lordship, the matter forwarded to the state level committee, but the state level committee has not considered on the ground that there is an ON. In fact, lordship, the DLC recommendation, your lordship will find at page 29. 26/6/2023.
Page number 20.
29. That was also considered in terms of this honorable court order that is reflected in, I have annexed the order page 26. 29 is the recommendation, lordship. Your lordship may kindly take the decision of DLC. As there is no admissible vacancy in the establishment of the ISKDC, it has been decided to represent the applicant against the admissible vacancy in the cadre of EP teacher in the establishment of DO Coringons in Sampanso. And the DO Coringons is requested to obtain the approval, the SLC. And the IS Coringons will furnish requisite record of the applicant to the DO Coringons. Accordingly, Lordship, this recommendation was forwarded. Lordship case 37, your Lordship will see. Forwarded on 1/9/2023,
Page number?
37.
Thereafter, it has not been placed before
Has
the
not
SLC.
been placed. Lordship,
Rejected.
exactly on similar situation, your Lordship has passed an order that is page 40. This is a covered case, Lordship. Your Lordship may dispose of in terms of that order, Lordship. Exactly on similar, so only dates and case numbers were different. Page 40. Directing to place the case of the petitioner before on the next available SLC. Only that limited area, Lordship.
Yes, madam, any objection?
Next time 11:45, right? So we just February just take it before.
No. Hey, it was 11 for application. They to consider.
After that, common charge, because I was, just last week was to submit everything. Everyone has submitted. This what it meant.
Yes.
Okay, we will pass the order to dispose of the representation.
And that it is actually not a representation.
Dispose of means now the matter will be placed before the SLC.
Yes, yes.
SLC will consider
Next
that.
available asset.
In terms of the common charge.
Madam, this 45 is the particulars that he has submitted in terms of notification.
After common judgment, the Department of Personal Department issued a notice. The whole pending cases should be submitted before 59. Accordingly, he has done it, so they will consider it in accordance with law.
That is, yes, next available.
May please your lordship, my lord, this matter relates to compassionate appointment. Initially, my lord, the petitioner's mother had submitted application for compassionate appointment because the petitioner was minor at that time. The petitioner's mother's case was also placed before the DLC, and now, my lord, after attaining majority, the petitioner has submitted his application. That is, he submitted his application.
No, the case of the mother was considered by the DLC.
DLC, my
And
lord.
DLC has rejected it on the ground that
On the
she is
ground-
underqualified.
Underqualified, but
Now,
for
subsequently, can a petition be
my lord, the
maintained? by-
petitioner's mother did not challenge because she could have challenged on the ground that in case of compassionate appointment, my lord, the appointment is given as per qualification. But she did not challenge because my lord, her father, her son has attained majority and subsequently he, my lord, submitted his application. In terms of, my lord, the last or annexure, your lordship may kindly see page 28, my lord. In terms of this order, page 28, my lord. Here also similar situated case that the petitioner of that petition, he submitted his application after attaining majority in terms of Honorable Supreme Court's ruling, my lord.
No, this decision may not help you because your case has already been considered by the DLC.
The
And you have
mother's,
been found underqualified.
But underqualified, but
And you have not challenged the same. Now the
she did not challenge because her son became in the meantime, he attained majority.
yes, Mr. Pego.
There is no the competent equipment is there in at the time of application.
That is there, my lord, but before that, my lord, his mother submitted her application.
It was considered as underqualified.
No, is there anything in the office memorandum that in the event of rejection of the case of mother, the son on attaining majority can file another
That is not
petition?
reflected there, but
So if it is not there, under whose provision we can direct them to consider your case now?
my lord, in terms of this order, my lord,
This order, whether
that
this
is
will
page
cover your
28.
case or not.
Page 28.
Here in paragraph number 3, it is stated that the Supreme Court in Sanjay Kumar versus State of Bihar and others had taken a view that in certain given circumstances, a person who was a minor at the time of death can also submit an application for compassionate appointment subsequently upon attaining majority.
So on this ground only he
No,
submitted his application.
Because the mother of the petitioner has already filed an application that was considered and rejected.
Yes, ma'am.
You show me any provision. If you can satisfy, then definitely we will pass the order.
Then
We'll list it in the next week
yes, ma'am.
or in the first week of January.
My lord, next week, my lord.
Next week. Heard Miss S.B.
On
Chaudhary,
15th,
learned
my
counsel
lord.
for the petitioner. And also heard Miss K. Fukun, learned counsel for the respondent number 6. And Mr. Fukun, 1 to 4, 1 to 5, 1 to 5. The petitioner herein as pride for issuing direction to the respondent authorities to place the case of the petitioner before the DLC, considering the financial status of the family. And also to pass similar order, like the order dated 8/10/2021 passed in WPC number 5497 of 2021. And also challenge the action of the respondent authorities by which the claim for compassionate appointment made by the mother of the petitioner was rejected. But having heard the submission of learned counsel for both the parties, it is provided that Ms. Chaudhary, learned counsel for the petitioner, on next date shall satisfy this court about the existence of any provision in any OM or any act or rule regarding the consideration of the application filed by the mother, filed by the minor son, filed by the son who attained majority after rejection of the claim made by his mother earlier on the ground of underqualified. List on 19th. On the ground of being underqualified.
Lordship, regarding non-payment of 13 area salaries, my lord.
Career salary.
My lord. At this stage, my lord, may issue notice, my.
Heard, Mr.
Jai Lord.
Learned counsel for the petitioner and Ms. P. Das, learned standing counsel for the respondent.
Respondent number 1 and 4.
1 and 4. And Ms. Borua for respondent number 3. Ms. Tinlong, respondent number. Principal Secretary. Respondent number 2, Mr. R. Kosik for respondent number 5. For AZ? Oh, no. Inspector of school, okay. And principal?
I am appearing only for 1, your lordship.
1.
Oh, number.
So notice has to go to the respondent number 6.
6, my lord.
6.
5 and 6. I am appearing 1 and 5.
No, inspector, yes, inspector.
1 and 4. So nothing to do.
In this petition, under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities to release his arrear salary with effect from July 2019 to December 2019 at the rate of 50% amount of the salary with effect from 12/12/2019 to 30/6/2020 and 25% amount with effect from 1/6/2020 to 10/12/2023. And also the increment with effect from July 2019. Where is the petition? The documents plus on record. Let notice be issued to the respondent. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, and 5, since they are represented by their respective standing councils. But extra requisite copy of the petition will furnished to them during the course of the day. Step upon respondent number 6 be taken by registered post with ADN also by usual
My lord,
process.
now it
within a
is
respective-
There's one mistake, your lordship. I am appearing for respondent 1. Since 4 additional director, there is a Dima Hassan. So your lordship, Haplon.
5.
4 and 5 will be appearing.
Okay.
I am
Okay,
appearing for
okay.
respondent.
However, step upon respondent number 6 be taken by registered post with ADN and also by usual process with any will come to the list of the forex. In the meantime, the respondent authorities shall file their affidavit in opposition.
And
No, now it is speed post, my. Now it is speed post.
But is it
Well-
but whether the rule is amended?
Lords. Of life.
You take step as per
My.
or
Number 26.
Matter part as a non-payment of family pension, my lord. At this stage, notice may be issued, my lord.
Heard Mr. Patgeri, learned counsel for the petitioner. Mr. Pegu for
2, 5, and 6.
2, 5, and 6. Mr. Bora for
1, 4.
1, 4, and 7.
7,
1,
8 also,
4,
my
and
lord.
7.
8 also depends, my lord. DI
8.
of school.
And treasury officer? Okay. Mr. Soliha for respondent number 9.
3 and 9, my lord. 3 and
3
9.
and 9.
The finance department.
The petitioner herein has bribed for issuing direction to the respondent authority to release the retirement benefit, arrear monthly superannuation pension left by the late father of the petitioner and the arrear family pension left by the mother of the petitioner and the arrear and current family pension in favor of the petitioner being the dependent unmarried daughter of the deceased employee. Deceased government employee. First, the petition and the documents placed on record. Let notice be issued to the respondents. But whether you have filed any application for
Already, my lord, already
completion of
matter is
family
pending,
pension?
my lord. Kindly see, my lord, page 35. Page 35. Earlier mother of the petitioner, my lord, filed proposal, my lord. That one returned, my lord. And in the meantime, she died, my lord.
Page number
Page 35, my lord.
35.
And Director of Pension, my lord, requested that DIF school, my lord, to resubmit the proposal.
Mr. Patgiri, learned counsel for the petitioner, submits that the father of the petitioner was serving as
As my lord, teacher, my lord, head
Teacher.
teacher of Tingori Sikaria LP school.
and he retired on superannuation on
30/9/1975.
30th 9 1975 and died on 19 9 1988.
8.
And after his death, the mother of the petitioner has received the family pension.
My lord.
Received or not?
Not received, my lord.
Applied.
Applied, my lord.
Mother of the petitioner has applied for releasing the family pension. But before the same could be settled by the respondent authorities, the mother of the petitioner suffered demise. And thereafter, the petitioner has filed one representation on
My lord, on my lord, 14/9/2022.
on 14/9/2022.
2, my lord, page 33, my lord.
Page number
Page 33. Is the my lord. And thereafter, my lord,
page number 30.
3, my lord.
33. But the same failed to evoke any response, and being aggrieved, the petitioner approached this court by filing the present petition. The submission of Mr. Patgiri needs further consideration that this is this notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their respective counsels. But extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks. In the meantime, the respondent authorities shall file their affidavit in opposition. List after 4 weeks.
Obliged.
It happens. Liberty will be required. Okay. Heard, Mr.
Yes, Burma.
Learned counsel for the petitioner. Mr. Burman submits that he has the instruction to withdraw this petition with a liberty to approach this court again by filing appropriate petition. Accordingly, taking note of the submission of learned counsel for the petitioner, this petition stands a disposal. No, this petition stands disposal on withdrawal. However, liberty will remain with the petitioner to approach this court again as and when necessary.
Obliged, Lord.
Please, Your Lordship.
Yes.
Lordship, the petitioner was working as the librarian of CKB College, Jorhat, Lordship. Lordship, she retired on 30th of April 2025 and pension is not released. Lordship, that's right.
Retired on
30th of April 2025.
you have submitted the pension papers.
Lordship, not yet, Lordship.
No, whether you have submitted the pension papers.
Yes, Lordship, the principal has to submit my pension paper before the respondent number 2.
Respondent number
2.
2. When?
No, they have not. The respondent has not yet initiated my pension proceeding, Lordship.
No, they have received the documents submitted by you, pension papers.
No, Lordship. In fact, what happened, Lordship, kindly peruse my additional affidavit. Annexure 1 of the additional affidavit, Lordship, on 11/4/2018, Lordship. The principal of my college has lodged a complaint before the respondent number 2 regarding the qualification of the petitioner during her appointment. Thereafter, a hearing proceeding was going on, and last hearing was held on 11th April.
Yes, Mr. Das.
Lordship, at this stage,
Hardness.
MS Mbora, Lordship.
MS Mbora, learned counsel for the petitioner. Mr. S. Das, learned counsel for the respondent number 1 and 2. Mr. Talukdar for respondent number 4. Ms. Fokon for respondent number 3. In this petition, the petitioner has tried for issuing direction to the respondent authorities to release the pension. And also to issue direction to the respondent number 5 to submit the